Hello everybody and welcome to today's session. It's great to see we have everybody just logging on at the moment. We've got a few more people trickling in, so I will just wait for you guys to hopefully get on board quickly. It's great to see we've got a lot of familiar names on today's webinar, so that is great because obviously you've found previous ones interesting and useful, so thank you for coming back to us for this month's webinar. We have some new names as well, which is fantastic. So welcome to this session. And I'm sure you're going to take away a lot of useful information about GDPR today, actionable tips that you can get to work on straight away that will help you work towards being compliant when obviously GDPR kicks in May. So today's session, it is Get GDPR Ready. So we're focusing particular today on staff data. So that is your current workforce and the data that you hold about previous employees as well, and how you handle that data and where you keep it and where you store it. Do you know where you keep it? There's a lot of things that you need to obviously bear in mind. We have had requests about service user information and their families and the next of kin and all that kind of information. So what we're going to do is after today's session, we are going to look at future webinars about GDPR and service user client information. So thank you of those of you as well who did ask questions and submit your questions prior to today's session. So these questions have been passed on to Kate, who's going to be speaking about GDPR with you today. And Kate's going to sort of talk about and touch on those subjects throughout the session. So if you just listen in, and I'm sure you'll hear the things that you've mentioned come through on that. So just a little bit about myself. So I am the host of today's webinar. I host these webinars try to host them on a monthly basis. So the key goal for me is we are working really hard to find useful information for senior leaders in social care. So that will be obviously managers, regional managers and directors and CEOs. You guys have got a massive workload to do day to day, and there is a lot of other things that creep in, such as GDPR, which is a huge thing coming in May, that you also have to comply with. So if we can sort of take any headaches away and help you get on board and give you the information, the tools that you need to be compliant in that area, as well as obviously all the other compliance that you have to follow, which is from CQC, etc. So my name is Rachel Bryan. I'm one of the senior managers here at Churro and AJ Recruitment, and I specialise in social care recruitment. So as I mentioned, love to share useful content. We've got a group on LinkedIn. I try and put as many blogs in there, whether it's regarding recruitment and retention, GDPR. We've got a lot of different specialists that we sort of hook up with and try and get and share all this information with you. Just a few random facts. Currently reading Fish Philosophy. I would highly recommend you pick that book up and you work with your team on this book. It's all about your attitude in the workplace. It's all about when people come to work, if they come to work in a negative mood, how can they flip that and use the tools to help them be as positive and as productive as possible in the workplace, especially under sort of the pressures that people are under in social care. It's quite difficult to remain positive all the time, but this book really helps with that. Our team are loving reading the book, and we're, as managers, we're really enjoying seeing them use them new skills in their roles. And I'm currently writing the Social Care Salary Survey 2018. So that's been going on since last year, and I'm now in the process of analysing everything. So thank you if you contributed to that. Thank you very much. Over 1,000 social care leaders have contributed to that. So, and that talks about, pay structures, bonuses, feelings towards pay, what are the biggest challenges that you're facing in your role. So that report's coming out early April. So as a participant of today's session, you will be one of the first people to receive that report, and I'll send that directly to your inbox. So just a little bit about who we are and what we do. So AJ Recruitment has been running since 2004. We provide specialist social care staffing solutions across Yorkshire and the Humber. And that is sort of 24 hours a day, 7 days a week. We do sort of the staffing support, we do temporary contracts and assignments, fixed term contracts, permanent placements, and temp to perm introductions. So the guys in their focus on their geographical areas are low, so they absolutely have their ear to the ground all the time, and they know which temps are available to your service at any one time if you find yourself in a position where you are understaffed, whether that's for one shift or whether that's for, you know, to cover a maternity leave or something that's a bit more long term. And Churro is the other side of our business. So the Churro guys, again, are split into geographical areas across the UK, and they focus on senior level roles in social care. So if you find yourself in a position where you need a new care manager, a domiciliary care manager, CEO or director, head of service, those are the guys who work on those roles, and they are really good at making sure that they have it's quite frank discussions with you about your organisation and its perception in the marketplace. They know what people think about your brand, the pay levels that you're offering, are they competitive? What are the peers in that sector are receiving pay wise on those sort of levels? Like you would specifically choose who you work with for recruitment, they also specifically choose which customers that they recruit for. They have quite a strict criteria who they do work with, so it's quite important to them that they find people and put people in roles that are going to stay, and that the directors in that position are getting the best return on investment. So obviously today we have Kate. Kate is someone who came on my radar earlier this year, and with regards to GDPR, I was looking for someone who could help sort of with training and support around GDPR, and who could explain it in a way where we can digest it quickly and implement it. We are also a care provider ourselves. We are a domiciliary care provider as well. So we absolutely understand, you know, the service user record side of things, the candidates that come through the interview process, the staff that work for your service, and all the data that comes with that. So we wanted to work with somebody who could really, you know, explain that to us really well. And Kate explained that to us in a way that I could digest it and understand what was expected of me and our organisation. So Kate is a partner at Eaton Smith in Huddersfield, employment law firm, and she specialises in sort of employers and contract and policy reviews, ongoing HR and employment law support. So if the worst should happen, Kate's the person that you need to speak to when it comes to anything to do with sort of employment tribunals and that kind of thing. So just before I hand over to Kate, just to make sure that you get the best out of our time together today, I just want you to make sure that obviously you've got access to a pad and a pen. So take thorough notes. There's going to be a lot to digest today, but also when you get back to your desk and you start to implement these things, you're going to want to reflect back on that and think, right, what is it that she said that I needed to do first? So if you can take thorough notes, that would be fantastic. At the end of the webinar today, you will get a survey, which is really important to us because it helps you feedback on, helps us get feedback on, you know, how you found the session, the information that you was given. Was it easy to digest? What other topics, what other challenges are you facing? Because I can then go out and seek the specialists and bring you this free training on the topics that you're really struggling with. So if you can give me those topics, that'd be fantastic, and I'll get to work on that straight away. There will be a recording of today's session, so all those people that obviously stay to the end, you will be able to get a recording that you can then watch back, digest in your own time, revisit the sections that you needed a little bit more clarity about, and also share it with your colleagues, because I know obviously we're all sort of under it, especially in the morning. It's quite a busy time, so not everybody can attend the live session. So if you have any colleagues who GDPR will affect too, it'd be great for you to share the recording with them so they can get the best out of this learning too. So I'm going to hand over to Kate, and Kate will then take you through the GDPR and staff data.
Okay, thank you. I'll just bring up these slides. Right. Hopefully you can all see my slides there.
Yeah, I can see them. Yeah.
Yes, they're looking okay.
Yeah.
First time I've done a webinar, so hopefully that's gone as smoothly as when we practiced it. So my name's Kate, and thank you very much for listening in this morning. I've put as much information as I can onto the slides. There will be plenty more that I need to sort of take you through, but hopefully the slides will prove very useful, and either Rachel or I can make sure you have a copy of them at the end. So if you want them, and it saves you scribbling everything down, then give one of us a shout, please. Okay, so I'll crack straight on. So what is the GDPR? I'm sure that by now you will have heard of it, although I still do have some clients scratching their heads and sort of going, well, what is this GDPR that's coming into force, which is a bit concerning. It's the new data protection laws that is coming in from Europe. And although we're embroiled in the Brexit negotiations, the GDPR is still going to apply to us, and it's being brought into UK law with a new Data Protection Act. So we don't have any sort of escape from it. It'll come into force on the 25th of May. So we do still have, you know, a good couple of months to prepare for it. So this is a well-timed seminar. If you've not had a chance to think about GDPR yet, you've still got time to make sure that you're compliant before it comes in. So no need to panic. It is very important that you can demonstrate compliance. This is the main sort of change from what we've had in the past. There's going to be sort of a more rigorous approach taken to making sure that firms and businesses are complying with their obligations. And then the penalties for not complying are very significant. So the worst case scenario is fines of up to 20 million euros or 4% of your annual turnover, whichever is greater. And obviously for smaller businesses, that's going to put them completely out of business. Now, I have heard sort of some fairly complacent approaches to the data protection changes, where people sort of think these fines won't really happen or won't really apply to them. And I think to some degree that's fair. I think the fines are a worst case scenario, and there would have to be a real failure in compliance and a very serious data breach for you to be facing a fine of that level. But there's always the risk that with new legislation like this coming in, that there's an effort to make some early examples of people in order to you know, make it clear that this is being taken seriously. And so there might be some hefty fines dished out in the early stages, and you wouldn't want to be one of the businesses that gets caught out by that. So in order to demonstrate compliance, then there are a few steps that you can take and that I recommend you take. And I would start with a data protection audit. So if you haven't done anything at all yet, then this is your starting point. And in terms of doing the audit, you need to be identifying what categories of personal data you hold and the purposes for which you hold it. So what have you got and why have you got it? But you also need to look at how you collect it. So with staff, that's often going to be directly from a member of staff themselves. But you might use third-party agencies, whether that's AJ Recruitment or Turo. You might also have information coming to you from other bodies, such as HMRC, or if you're doing criminal records checks or credit reference checks, and indeed references from other employers. So there are sort of third-party sources that you need to sort of think about as well. Identify what you do with the data once you've got it, and whether you're entitled to do that, whether you need to do it. Think about security of the data that you have. So are there any risks associated with that data being accidentally destroyed or lost or disclosed? And then look at the security that you have in place to try and prevent those risks. You also need to include in your audit some consideration of what you will do if there is a breach of personal data security. So obviously you want to be taking steps to prevent that breach, but you need to think about what you will do if a breach comes about, so that you're prepared for that moment. And that needs to include logging the incident, rectifying the problem as soon as possible, establishing learning points, and identifying whether you need to notify the Information Commissioner's office. So you won't need to do that in every case, but if it's a serious breach, you might need to put your hands up to it. So I would recommend that you approach it in a sort of similar way to you might might do risk assessments in a health and safety field. So you've got identifying the problem and what solutions you would be putting in place to address it in terms of your security, and then learning points for moving forwards. Okay. You might need to carry out a data protection impact assessment. I've stuck a question mark next to that. On the whole, I think within the social care side, you're probably not going to have to do one of these impact assessments for staff data. It might be that you need to do one for your service users, which is a slightly separate topic than today. So an impact assessment is only really needed if you process information about criminal offences, or if you monitor the activity of your staff on a large scale. And when we talk about monitoring your staff, we're thinking about, are you monitoring their workstations and internet activity? So you're probably not doing that unless you go so far as sort of almost tracking your staff with sort of GPS type trackers, so you know where they are throughout the day, more than just sort of having a bit of a rota, but actually sort of almost invasively sort of tracking their whereabouts. And if you listen into calls for them, so some businesses will listen into calls for training or whatever purposes, so that sort of thing. So consider whether you do any monitoring on a large scale. And the other side is if you carry out extensive profiling of staff involving automated decision making. So if you're putting into sort of some computer program information about their health or something, and you're using that to predict their behaviours, then that would be what we mean by profiling and automated decision making. I think that's pretty unlikely within an employee context. It tends to be sort of a marketing activity that you would see that come in. And so hopefully you won't need to do the impact assessment. A big one is to introduce a data protection policy, and that will sort of flow automatically from your audit. So the information that you've collected in that audit process will be very helpful to you in putting together a data protection policy. If you have one in place already, that might just need some modification, or if it's not something you've looked at before, then I really recommend that you do put one in place. It's something I can help you with if needs be, and would be happy to do so. I'm going to come on further on in the slides into the sort of headings that you would have in your data protection policy. So we'll have a bit of structure that will help you do some drafting yourself at your end. You need to make sure that you implement that policy. So it's no good having it sort of written in a manual. You need to make sure that you've given it to your staff. So make sure they know where it is so it's easily accessible. And I would recommend going one step further and actually handing out copies of it to your staff. The reason for this is that you're required to give staff a privacy notice that sets out what personal data you're collecting about them and what you do with it and what their rights are. So if we put all that information into your data protection policy and hand that out, it saves you duplicating the work effectively. So the one policy can be your privacy notice as well. The way I've done it with some of my clients is we've stapled it to payslips so that we know that the staff have got them. You could also email it out with a read receipt facility on it. And then I know some employers still like to put a signature receipt slip with policies and handbooks to be signed and returned. My feeling is that creates a lot of extra work for you, especially if you've got workers who are remote and you don't necessarily see on a daily or regular basis. Then chasing in those signed slips is going to create a bit of a headache for you when you're already busy with other things. Okay. Make sure that you're reviewing your processes regularly. So with that audit and policy, keep an eye on them and update them. I'd recommend every 12 to 18 months that you do that, and then document that you do that. And that could be as simple as having a little table at the bottom of your policy that says that, you know, it's been reviewed, who by and on what date. And it might be that as a result of the review, there's no changes, but at least you've recorded that you are keeping a regular eye on it and you're being vigilant. I would recommend that you designate a data protection manager. Be a bit careful about terminology. Under the GDPR, the job title data protection officer means someone who is qualified in dealing with data protection. and some organisations who process data on a very large scale need to have a data protection officer in place who is qualified and who would report to the Information Commissioner's office. You probably don't need that on the staff side of your business, but you might need that on your service user side. On the staff side, a data protection manager, you could have someone who is perhaps either in your HR team or on your management team, who's going to take responsibility for writing and reviewing your policy and dealing with subject access requests as they come in. And they don't need any sort of huge amount of training. They might appreciate a bit of awareness of how to deal with subject access requests and so on, but they don't need to sort of be quite so formally sort of qualified perhaps as the data protection officer. If you have 250 employees or more, then you should keep a record of your data processing activities. That I'm anticipating that won't apply, but something to bear in mind. Okay. So I thought it would be helpful to just quickly have a look at what is personal data, just in case there's any sort of query on that side, because it's not always as obvious as we think it is. I think 90% of the time it's pretty obvious, but just to make sure that we're all thinking about the same things. And this will be particularly relevant if you get a subject access request from a member of staff saying, I want to see all personal data that you hold about me or all information that you hold about me. Trying to sort of think, well, what does that include? So the definition that we have is on screen now for you. It's any information relating to a living individual who can be identified from that information, or if they can be identified from a combination of information that you have about them. So you might have, obviously documents with their names on, but you might have other means of identifying them, including an employee number or job title. And if you can still work out who it is from that information, then it still is going to count as personal data. If you can answer yes to the next 6 questions, then it's going to be personal data. So it's a bit of a checklist in case that's of help to you, and this comes from the formal guidance that we have under the GDPR. So this one is, as I've already said, from the definition, can the individual be identified from the data or a combination of that data and other information? Other questions up there are, does the data contain significant biographical information about them? So merely recording the involvement of an individual in an event won't be biographical and won't in itself be enough. For example, if your individual attend a meeting and you've got the minute of the meeting just at the top record the fact that they are there, that in itself is not going to be personal data. Because all we've learned is that they were sort of physically in a room at that time. But if it goes further than that and they have an involvement in the event or transaction, then it becomes personal data. So for example, if it's an appraisal or grievance or disciplinary meeting about them, then it's personal data. If they've accompanied somebody to a meeting like that and stayed largely silent, then there will only be personal data about them at the times at which they perhaps have expressed their opinion or view within the meeting. So for example, you might have someone accompany their colleague to a disciplinary hearing and sit quiet as a mouse right until the very end, at which point they say, well, do you know, I think this is all very unfair and Brian is being treated abominably and I don't think you should sack him and blah, blah, blah. That last paragraph where they speak, that would be their personal data. So if that person contacted you with a subject access request, you wouldn't give them the minutes of the whole meeting. You would just give them that little bit where they've spoken, partly because the rest of it isn't their personal data, and partly because the rest of it is someone else's personal data, and obviously you run the risk then of giving them confidential information relating to someone else. So that's what I mean when on number 3, when we're talking about, are they the focus of the data? Does the data obviously relate to them? Is it about their personal life, or is it recorded to learn something about them? And then 5 and 6 talks about, will the data be used to inform or influence decisions or impact on the individual? So The sort of obvious example that springs to mind is if you're having discussions about a possible redundancy or restructure programme, you won't necessarily be able to identify specific individuals at the start of those discussions, but as they move on and you're looking at teams and job roles, and you're perhaps sort of building up the selection criteria, and you're starting to think about scoring the staff, then at some point we're going to be able to identify who you're talking about, and we're going to know that what you're doing there is going to have an impact on decision making about their future. So that becomes personal data. So the discussions about the selection criteria and the redundancy process there would start to become personal data, and they would be able to request copies of that. As an aside, I think it's always worth bearing in mind that these subject access requests can come in, and that you need to be very careful about what you put down in writing. There's quite often cases of somebody sort of being bad-mouthed on an email or in a note somewhere, and then the dilemma arises of the fact that you have to hand that over, and it doesn't look good. Okay, so that's personal data. In order to assist, I've done a list of staff data that you're likely to hold. Now, as I said, we're going to look at data protection policy a bit further through the slides, but one of the things that you need to include in your data protection policy is what personal data might you hold about employees. So I've done a list on the slides, and as I've said, you can by all means request a copy of the slides off me and Rachel to save you trying to write these down, and rather than spend time reading them out to you, I'll just sort of leave that on the screen for a moment. But you can see it's fairly obvious stuff, isn't it, that that you would need to be collecting and keeping on a personnel file. So any sort of correspondence or minutes that you have in relation to the employee, medical history and accident books, sort of fairly obvious as well. You might do alcohol or drug testing. That's becoming a bit more commonplace, I think, in workplaces nowadays. And then you've got data obtained through monitoring. I asked earlier on for you to have a think about whether you do any monitoring. For example, you might have a call log which shows when one of your workers enters or leaves a service user's premises as a means of recording the time they were there, both for billing the service user and presumably for sort of a bit of a health and safety check, so you know when people are coming in and out of their homes. But if you're doing that to make any decisions about the employee, then that would be personal data, and that would be monitoring. So if it affects their, perhaps their appraisal or their pay. GPS trackers, if you put that in one of the vehicles. CCTV, if you have that, even if the primary purpose isn't to sort of monitor the employee, they're still going to be sort of captured on film. So think about how you use that. Okay, and I've also said there that you might end up with third-party personal data, most likely where you have an emergency contact, and otherwise on pensions and insurance beneficiary forms. You need to have a think about what you do with that third-party information. Where you are administering an insurance or pension type benefit, then you probably don't need to hold that beneficiary information once you've passed it on to the scheme holder. You could probably destroy it at your end rather than worry about whether you keep it securely and all the rest of it. So hopefully the third party information can be sort of more or less limited to emergency contact, and that should be given to you voluntarily anyway. In terms of processing personal data, I mean, it's anything that you do with it, really. So even if it feels like the data is fairly dormant because you've put it in a cupboard and haven't really thought about it, the fact that you're storing it will still count as processing. So anything that's in your possession, whether you're just storing it or whether you are actually using or disclosing it, will count as processing. So it's a very wide definition. I think there's lots of employers at the moment who've got cupboards full of old staff files that just haven't had time to sort out because it's not urgent, it's not a priority, and some things might be years and years old, and suddenly there's probably a lot of shredding going on up and down the country as a result. The GDPR does allow individual member countries to create their own specific rules about employee data processing. I think there's a recognition that that there might be sort of a move to make it a bit less onerous in terms of employee data, because it is so necessary and so hard to avoid. We don't have anything yet, except for a comment on consent, which I'll come on to, but it might be that our government does introduce some guidance or some rules that might make life a bit easier in relation to employee data, and we can only hope that that comes along. So in terms of the new rules under the GDPR, the good news is that they're quite like what we already have under the Data Protection Act. So you might already be familiar with the fact that there are 8 principles under the Data Protection Act, and you might have a policy that already sets those out. There is a very big overlap with the GDPR, so it's not completely rewriting the rules on this. I've put on this first screen a list of where the GDPR and the Data Protection Act sort of overlap. So you can see that there's lots of common ground, including that you must process the data fairly and lawfully for limited and stated purposes, and you must not keep the data for any longer than is necessary for those purposes. I have had a question come in from one of the attendees today about how long you can keep personal data, and I'm going to come on to that a bit shortly, but just so you know, I have seen it and I will come to it. Okay, so that's where we've got some good overlap with the Data Protection Act. There is one new rule I've put there, it's the second from the bottom, and that's that you must anonymise or delete personal data once the purpose is fulfilled. And although that's new, in my view, that sort of overlaps substantially with the idea that you shouldn't keep data for longer than you need it. It's interesting that you could potentially anonymise it and keep it if you had had a wish to do that. Unless it was potentially helpful for some kind of research. I don't know why you would look to do that, but the option is there. Remember that just anonymising it won't be enough if the person would still be identifiable by a combination of that data and other means. So it wouldn't be as simple as just scrubbing their name off the top of a document. Okay. The other area of overlap is about transferring personal data outside of the EEA. As an employer, it's unlikely that you would be needing to do that anyway, unless you're sort of using companies to process benefits who are actually sitting outside of the UK. Most of your data transfers would be internal to the UK, so sort of to HMRC and so on. So you shouldn't be hopefully needing to go outside of the UK. If you do, the member countries of the EEA are deemed to be secure because they're all having to comply with the same rules. So you can transfer within the EEA reasonably confidently. If you need to go outside of there, you need to make sure that wherever you're sending it to has got appropriate security laws in place for data protection. Otherwise, you're exposing yourself to a potential breach of data security, and that's where you might end up with one of these fines that we looked at the very start. The new rules that have come in are fairly interesting, and they're more about the rights of your staff. So you have to give them information about what you're processing and why, and how long you're going to keep the information. That's the privacy notice that I mentioned at the beginning. And as I've suggested, if you have a good, strong data protection policy, then that would cover this information and would serve that purpose for you. You also have to allow your staff the right to access, correct, and erase their personal data. So this is being referred to as the right to be forgotten. And I've had a question pop up as well in relation to that. So thank you for that question. I'm going to come on to that one as well. But as essentially, the right to be forgotten isn't a blanket right, and you can't just have any employee, past or present, come to you and say, right, I want to be forgotten, and then you have to scrap their personnel file. It's not as strong a right as that. In fact, it's fairly limited, and so please take some comfort from that. And finally, you have to be able to demonstrate compliance with the rules. And as stated, if you can't show compliance, then that could become very costly for you. So moving on to thinking about the collecting of employee data, and the big question is whether or not you need consent. And the answer is not always. And in fact, I would say hardly ever. I hope that's helpful and reassuring to you, because the need for consent is retrospective. So where you do have to get consent, it's not just going to be about new personal data, it will apply to old personal data as well. And the main area for the GDPR to target is about marketing. So we all get bombarded nowadays with emails and calls from marketing people who've got our data somehow. The fact that they have a database before the 25th of May that haven't got our consent attached to it won't help them. They would have to get retrospective consent to keep using it. So hopefully the number of phone calls you get will go down. But anyway, back to employee data. It doesn't really apply in the same way, because there are 6 reasons or 6 lawful bases on which you can process personal data, and consent is really the last one that you would rely on. So for your employees and your staff, the key ones are that it's necessary to fulfill the contract of employment. So you're going to need to collect information from your staff in order to give them work, pay them, look after their sort of interests under the contract of employment, administer any benefits to them that are under there, including sick pay and so on. So a lot of the personal data will be captured in accordance with the contract. And if not, then it's going to be captured in accordance with a legal obligation, because of course you have obligations in terms of paying minimum wage, ensuring minimum breaks, giving out sort of appropriate maternity leave and pay, that kind of thing, ensuring health and safety. Hundreds of laws in employment law protecting your staff. So in order to comply with them all, you're going to need quite a lot of data there as well. And then as you are sort of in the private sector, you also have at number 5 there, a genuine and legitimate reason to process the personal data. So even if something doesn't obviously fall within those first 2 that I've stated, you're going to be able to use this genuine and legitimate reason, provided it outweighs harm to the individual. And the law does recognise that you need to be able to manage your business and manage your staff. And that does mean disciplining them, doing absence management procedures on ones who have poor attendance, even if it's through genuine ill health, dealing with grievances, dealing with poor performance, all of that sort of thing. You have a legitimate need to do that, and so you can collect data that relates to it. So only if we can't rely on any of these other categories would we come down to asking for consent from the individual. Now, you might sort of think to yourself, well, actually, why don't we just get consent and then we know we've got it and we're covered? I would advise against doing that. And in fact, the Information Commissioner's Office has published guidance which says you shouldn't do that. And the reason is it's a bit misleading. So if you tell your employee that they can consent to you doing this, collecting their data and holding it, if you ask for the consent, the implication to them is that they can also withdraw consent. They sort of think that they're holding the power, if you like. But in reality, you want to and will process the data anyway, whether they consent or not. So don't give them the power to consent or withdraw, because it's going to create a headache for you. And that's very much what the Information Commissioner's Office is saying as well. So before, on a sort of 3 slides, I had given you the types of personal data that you might be collecting, sort of common categories, and I've tried to be as thorough as possible. And over the next few slides, I've then married those categories up with these lawful bases for processing. So you can see that you just don't need consent in most cases. So again, I won't sort of take you through every single one of them, but I've popped them up on the screen and you can request copies of the slides. So for example, financial information in terms of what they get paid, their benefits, pension insurance, sick pay entitlement, all that sort of thing that's in the contract. that personal data is necessary for you to administer those payments to them under the contract, and it's also probably a genuine and legitimate need for you to process the data, so you don't need consent for that. Similarly, collecting in references, you've got a genuine and legitimate need to check the integrity and past of your staff coming into your business, so you don't need consent for that, although you would usually be asking them to give you the information of the referee anyway, so you would do that, but you don't need consent to then hold the reference on your file. Accident books, that's necessary to fulfill legal obligations in relation to health and safety. Also, it would be potentially necessary to defend a claim. So I haven't put that on there, but oh no, it's on sensitive personal data. But if you do need to defend a claim against you, then that is a reason also to keep hold of data. It would be a genuine and legitimate need too, and it's also, when you look at sensitive personal data, it is a reason for you to be able to hold it. Information about medical conditions, that's the last one on this slide. I've said consider getting consent there, and what I'm thinking about here is having information ready that you might need to hand over if you ever have to call an ambulance for that member of staff, you know. So are they allergic to any kind of anaesthetic, or do they have any condition or medication that a paramedic needs to be made aware of? And arguably you don't need to get consent because you're doing it to preserve life, and there's a genuine and legitimate need for asking for it, but I would just ask staff to give you that information voluntarily and let them know that it's going to be sort of held very confidentially and would only really be used in the case of an absolute emergency, like they've collapsed at work, that sort of thing. That's sort of information about your processes. As I said, it's usually going to be a genuine and legitimate need to manage your staff through your processes. And then information obtained through monitoring, I've put on there. That's probably going to fall under a genuine and legitimate need as well. Monitoring, I've done whole seminars on monitoring on its own, and it can be controversial, but the position that we've reached is actually that you can monitor your staff, provided that you have clear policies on what you're going to do and why. So I'll have a very brief look at that for you now. So this is what I mean by monitoring your employees. You might be checking call logs, which I think might be one of the more common things for you. You might have staff who swipe in and out if you have a sort of a sophisticated fob system, or they might just be calling you as they enter and leave service users' premises. So call logs. You might listen to calls, reading messages and emails, and checking email logs. Facebook comes up a lot in disciplinary type matters, and then you've got your obvious sort of GPS and CCTV. Now, the case law on monitoring has almost resoundingly come back and said that an employee doesn't really have a right to privacy in many circumstances when they're at work. The private investigator case, if I deal with that first, that was a guy who was claiming to be off sick, but was caught on camera by a private investigator playing squash at his local leisure centre. He was dismissed, and he tried to claim that there had been a breach to his right of privacy. And the finding was that he could have no expectation of privacy, first of all, because he was in a public place. So it wasn't like they'd filmed him through the windows of his house or in the changing room. He was on a squash court. And second of all, because he was already in the wrong. So him sort of being dishonest and acting without good faith then meant that he couldn't sort of have expectations of people treating him with a right to privacy, if you see what I mean. There are loads of cases about Facebook and email, and the general principle that's come out of those is that you can read any personal data that's on a member of staff's Facebook, because there's no real privacy. There are privacy settings on there, but really it's not very private. Once things are on there, they can be shared and seen by quite a big pool. And the tribunals have repeatedly said that an employee cannot have an expectation of a right to privacy for information that they've put on Facebook. They might as well have put it in the local paper, really. Reading emails and listening to calls is where it gets a little bit more contentious. And this is where you do need to make sure you've got a very clear policy of what you're doing. And this can go in your data protection policy as well. So tell staff that you will do it and why. So, for example, tell staff that you will read the body of emails that they send, even if they're marked private. And that's because you want to be able to cover work if they're off sick. You want to be able to investigate grievance and disciplinary procedures and complaints about perhaps that person. You want to make sure your policies are complied with. You might need to access email, extreme example, if the police get involved about something. So those are loads of good reasons why you might want to read email. And once staff know that you are going to do it and why, they can't have an expectation of privacy. So if they then spend a Monday morning emailing their mum about how their verrucas have got worse or whatever it might be, they can't expect that information remains private and you're allowed to access it. It's all about making sure it's clear what you're collecting and why, okay? So I got a bit ahead of my slides there, but that's the information that you need to give them and that I would expect you to put either in your data protection policy or elsewhere. Sometimes you might have it in your IT policy attached to sort of email and internet sort of etiquettes. You might put it in there, okay? If you do have to get consent from a member of staff, and as I said, I think that will be in a very limited number of cases, then you need to be giving them specific and informed consent forms. It's a terrible sentence, but essentially give them clear information about what they're consenting to. So what information you're getting and why you're getting it, and that they have a freedom to give consent or not as they like. They're not being pressured to give the consent. The most common example is when you're asking an employee to consent to a medical report. So you will be familiar with this process already, I imagine. It's fairly common practice already. And it's a good example of how a privacy notice might work. So if you've got an employee with a health problem or who's been off sick for a while, then you might want to write to their doctor. And you would probably, what you should be doing is giving the employee a letter explaining to them what you want to do and why. So we want to write to your doctor. We want to get more information about your health condition and the impact that it has on you. And the reason for this is we want to understand when you can come back to work, whether we can make any reasonable adjustments to help you come back to work, what standard of performance we can expect from you, whether we need to be looking at other jobs for you, or whether ultimately we might need to look at dismissing you. You've probably sent letters along those lines before. And then somewhere in that letter or in the consent form itself, it needs to say to the employee, you don't have to give this consent. You can choose to consent to the medical report being done and sent to us, or you can ask for the medical report to be sent to you and then you read it and decide whether it can be released to us, or you can refuse your consent altogether. So then they know they're giving free consent. And you can say within there as well what the repercussions are for not giving the consent. And that's not undue pressure, but you can say in there, if you don't want to consent to us having the medical report, that's fine, that's your decision, but we need to make a decision about your ability to continue working for us, and we will make that decision without the benefit of the medical information. So you can include that in there. So the strong inference is, look, if you're not going to cooperate with us, we might end up deciding that we can't help you back to work and we have to dismiss you because you're not helping us decide anything different. So that's what I mean by a privacy notice and getting a freely informed consent. So you will actually be already doing it. And there's not too many other circumstances in which you would need to go through that process. Okay. A quick look at sensitive personal data, because that category of its own, most of it will sort of be irrelevant to the employee work, and it might be information that you actually collect on a separate sort of equality or diversity monitoring form. Some employers are doing those. So when I talk about collecting information about racial or ethnic origin, political opinion, religious belief, or sexual orientation, Those are the kinds of things that probably would be tick boxes in these forms that would be anonymous, would be separated off from an application form and not kept on the personnel file, in which case it stops being personal data because you can't identify the individual from it anymore. So the only ones on there that are sort of more interest to us are your trade union membership. Why that's sensitive personal data, I don't know, but it is. And you would be processing that. For example, you would always tell an employee they can bring a trade union rep to a disciplinary hearing with them. So you might become aware of their membership that way. You might need to consult with trade unions about TUPE or collective redundancy. So you might find out about it that way. In all cases, it's probably going to be sort of voluntarily given to you. So I don't think you need to be sort of overly concerned about the fact that you've become aware of sensitive personal data about trade union membership. And the other side of it is health. So we've said already that you might legitimately have information about health already because you'll have sick notes and accident books, and you have a legitimate need to process that information to comply with legal obligations. And then further sensitive personal data, such as a medical report about a condition, you would go through the process of a privacy notice and consent, which we just had a look at. So the sensitive personal data that you process will be fairly limited, and you don't need to be too sort of bogged down in it. The general rule is you should only process sensitive personal data with express consent unless you're complying with your legal obligations, protecting life, defending a claim, which I've mentioned earlier there, or as I said before, if you've got the consent. So you can still be processing the data. And as we've already looked at, we're going to be able to use compliance with a legal obligation quite a lot. That's very useful to you. Bringing or defending a legal claim. If there's information that you've got about someone's had an accident at work, you can hang on to that data because you might want it to defend a legal claim. All right, so I said that we'd have a look at what you'd include in your data protection policy. So I've put up the main headings there for you. Odd as it sounds, you should put your name and contact details on it, although it would be in your handbook. For it to be a privacy notice as well, it stipulates in the guidance that your name and contact details should be on there. So I would sort of print it out on your headed paper, or just put your name and address of your business at the top of it, and then you've ticked that box fairly easily. We've said you'll have a long list of the sort of personal data that you're going to be processing, sort of in categories, and I've already provided you with that list. So that's another easy win, hopefully. Where you get the personal data from, so we've had a think about that, haven't we? So you might get it from your recruitment agent, and you might get it from references from HMRC, but most of it's going to come from the member of staff themselves. The big purpose is, why are you processing personal data? So I would be putting in there that you're processing it in order to carry out the contract of employment and your obligations under it, and also to comply with your legal obligations towards the employee, and also to ensure good HR practice and management of your staff. So that's like your legitimate interest, isn't it? So to ensure that you're managing your staff and business and following good practice, some wording around there. The basis for doing it, the lawful basis is what I mean there. So you need to include that. And again, we've done that on the slides, haven't we? So you've got the list of data you're collecting, and then we've got the lawful basis that you might use. So you can more or less crib that straight from the slides. And then whether you're sharing personal data with third parties, and if so, who they are, and what you're sharing and why. So that needs quite a bit of thought. I've done quite a few policies with my clients already, and this is an area that we've spent a fair bit of thought on. Okay, so have a good think about it. Training providers would be on there. Pensions and other benefits providers would be on there. If you have outsourced HR or payroll services, you probably put those on there. If you sign employees up to licenses or pay for qualifications and memberships for them, that will probably need to go on there as well. And then also how you get rid of data. So if you use a confidential waste shredding service, then you will be handing data to them to shred for you. So put them on there. HMRC would obviously go on there. Trying to think of further ones off the top of my head. I think those are probably the main ones, but you need to have a really good think about where any of your data might end up going, and do spend some time on that. That's an important one. Think about whether you send your personal data overseas. Hopefully you're not doing, but if so, you'll need to stipulate where you're sending it and why. And now we're on to how long might you keep hold of personal data. So I would recommend that you have a table in your policy that sort of puts data into almost categories and then says how long you would keep them. I think you can justify keeping all personal data about staff for at least the whole of their employment. And then after that, we're sort of looking at categories of data and how long you keep it after then. So remember that an employee can bring a claim against you for unfair dismissal or discrimination anytime up to 3 months after they leave you, or 4 months if they've gone through ACAS first. So you want to keep almost the whole file for at least that first 4 months in case you need to defend a claim. After that, the only claims they would have against you really would be for breach of contract, which would relate to failure to pay them sums due to them, and they have 6 years to do that, or for a personal injury claim, and they have 3 years to do that unless they don't become aware of the injury until later. So I would then be keeping accident book records for at least 3 years, and I would keep basic information about sort of the contract that says what payments were due to them, and confirmation of payments made for perhaps 6 years. I would hang on to that. And then don't forget that HMRC can open investigations anytime within about 7 years, I think, is how far they cast their net back. So you would keep similar pay information for that sort of investigation for up to 7 years. So you can see how you justify hanging on to quite a lot of data for quite a long time if you need to do so. The question that I was sent, it was sent to me anonymously because Rachel's very good at complying with data protection, obviously. So I don't know who's asked it, but it's a really good question. And it says, with historic abuse claims becoming more prevalent, what are the thoughts about retaining employee records? So obviously the concern then is perhaps that a service user might claim some kind of abuse at a future date, and then it's how do you defend yourself and what data do you need? As I've said, you can decide how long you keep data. There's nothing in the GDPR that stipulates maximum time. You decide what is needed as long as you can justify why, okay? And it's all about balancing your interests against the interests of the individual. So if you've got no reason to suspect an individual of being an abuser, for want of a better word, then you've got no reason to keep their data beyond, say, the 7 years that I've suggested would be sort of the longer period. But if you've had complaints about them, if there is reason to suspect that they might be an abuser and that you might need information about them, then you would have a reason to justify keeping it for longer. But probably in that scenario, I would have thought you would maybe have had an obligation to report it, depending on what it contains, of course, but probably that data would be in use already. Remember as well that if you don't have data, to some extent the claim against you would be harder to make out. So if somebody is saying, well, I know that I used to have somebody come and visit me and it was a man, but I can't remember who it was. If you don't have the records of what employees were calling on that service user at that time, because it's now years and years later, then it becomes a lot harder for the claimant to make their claim out as well, because it starts to become very uncertain and very difficult to prosecute. So the fact that you don't have the data wouldn't necessarily be of great harm to you. It might be something that you want to talk to your insurance company about as to whether they have any strong views on it. So identify your data protection officer if you have one, or your data protection manager, which I think might be more appropriate. including there the rights that an employee has. So the fact that in certain limited circumstances, they might be able to refuse consent, that they can access their data by making a subject access request, and they can ask for it to be erased or updated, and information about how they might complain to the Information Commissioner's Office if they think there's been a breach. So a quick look at individuals' rights, and then we will wrap up. So I'm conscious of time, but I think I'll only be another 2 or 3 minutes. I know you need to press on with your day. So an individual has a right to be provided with a privacy notice. So we've already mentioned those a few times now, and the fact that a copy of your data protection policy should cover that. They can make a subject access request to find out what data you've got about them and correct any inaccuracies. It used to be that you have 40 days to comply with that, and you can charge a tenner as an admin fee, and that's gone. So it's 30 days and you can't charge a fee, okay? And we said at the beginning there, when we were thinking about what was personal data, that you would redact information that wasn't. So you know how to identify what is personal data now, and you also know that you can block out the rest of it. So if you had an email or a set of minutes that had a tiny bit referring to the person making the subject access request, then you can cover up the rest and they don't get to see it. So they don't get to sort of fish around and find out extra information. They can object to you processing their personal data. They can only do that if you're processing it for direct marketing purposes. Hang on, I think you're pressing. They can only object to you processing their personal data if you are not pursuing a genuine and legitimate interest. I'm sorry, I think that slide's a bit misleading, isn't it? So you give them the right to object, and they can object, and you can ignore that, okay, as long as you have a genuine and legitimate interest for doing so. So you override the objection because you have a compelling legitimate ground for carrying on the processing, okay? So that's how limited the right to object is. Direct marketing would never be a legitimate interest. The matters of substantial public interest and historical and research purposes, they would also override the right to object, but I think would probably have limited application in your case. So they can access the information and they can object to you holding it, but most times we would override that right to object by saying we still have a legitimate need to process. And finally, the right to be forgotten. They can ask for their personal data to be erased, but that only applies if the need to process it has come to an end. So whatever purpose you were collecting it for has now come to an end, or you were doing it unlawfully in the first place, or they've already gone through the process of objecting and you couldn't show that you had the overriding legitimate interest for carrying on. Or lastly, if consent was needed and they've now withdrawn the consent. And we've said that we're going to keep consent very limited, haven't we? So actually the right to request erasure is so narrow. It's only where you don't need the data anymore anyway, in which case who cares? Or it's where they've objected and you just can't prove that you have a real need to keep hold of the data, in which case you probably shouldn't have it anyway. Or it's where actually you should have got consent and you didn't, and we've already said that's for a very limited range of circumstances. So although there has been sort of a bit of noise about the individual's rights, the new rights are quite limited. There's just a quicker turnaround on subject access requests, the right to object and the right to erase that are very, very limited. So I hope that takes some comfort for you. So the last question that I have been sent asks about, in respect of the right to be forgotten, how does this affect live disciplinary sanctions? Now, I've said I think that you have a legitimate need and legitimate interest to hold on to personal data throughout the whole of somebody's employment with you. So a live disciplinary sanction, or even an expired one, I think you can keep on a personnel file at least until they leave, and probably until at least 4 months after they've left, as I've said, because they might bring a claim against you, so you want all that information there. The reason, of course, for keeping it live is if they do similar offences again, you might want to step up the disciplinary process. But even when it's expired, it can still be useful to know what warnings they've had, because if they do the exact same thing again, you can still justify a worse disciplinary sanction the second time because they knew that they oughtn't to have done it because they've had a warning before. It's also useful if you're doing a redundancy process and there's not much between two people, but one of them has an old warning on file. That sort of means that they deserve to be the one picked out over the other one. So I would hang on to that information, and I think you can justify doing so. I've also been asked, are there any exemptions for charities or small organisations? And unfortunately, no, I don't think there are. I think that the difficulty with the GDPR is it applies to everybody, from someone who is sort of a tiny family business with a very small number of staff, right through to huge corporations, and it's being applied in the same way with the same huge fines. And that makes it feel quite difficult and unfair for a smaller business, I know. But I'm afraid I can't give you any comfort on that one. So, Rachel, that brings me to the end. I hope that didn't feel too rushed. I've put as much as I can on the slides to be helpful to you. And if you contact me or Rachel, you're very welcome to a copy of them. And of course, this has been recorded. So if you need a good cure for insomnia, you can listen to it all again at your leisure. I'd be very happy to hear from any of you who have questions arising from this or who need some help with a data protection policy. My email address is here and my telephone number, so please feel free to get in touch with me, and thank you very, very much for your time this morning. I do appreciate you tuning in.
Thank you, Kate. Thank you for that. That was absolutely brilliant. As Kate's mentioned in her slides, we've had questions sent to us prior to the session today, and the key thing for that to notice is that we have tried to obviously address them throughout this session, but also sorry, I think there's a bit of a sound issue there, that we are able to answer your questions after this. So please do send your questions to myself and we will get them answered for you as soon as possible after today's session. A few people did raise their hands throughout that. We did see that you're raising your hand, so please, like I say, get your questions across to us. I'd just like to remind people that we are on LinkedIn, so do connect with us, and we do share lots of useful blogs and information in there. There is a group called Care Providers Knowledge Hub. Hopefully you guys will get into that group and join it. It is a very protected space. We only let the sort of leaders in social care in there, so hopefully you guys will be able to get a lot of useful information from that. Actions after today's session. I want to make sure that we obviously get across to you the slides so that you can digest them again in your own time, and that you can obviously share them with your colleagues who might be interested in the subject as well. Mention the survey at the beginning. If you could complete that, that'd be absolutely fantastic. It gives us a lot of useful information about how you found today's sessions and what you took from it. The Social Care Salary Survey 2018, like I said, is underway. The analysis is underway and the report will be out at the beginning of April. So I will make sure that a copy of that is sent directly to your inbox. And also, once the webinar recording is fully downloaded, we can get that across to you as well, so that you can obviously rewatch it and digest it and share that with your colleagues too. So that brings us to the end of today's session. So thank you very much for joining us. Hopefully you've taken a lot from that today. Kate's information has been fantastic. And obviously the slides will be really helpful in getting you sort of up to speed and getting that actioned and put in place and ready for May. So thank you again for joining us, and we'll be in touch after the webinar today in your inbox. Thank you.
Thanks.